Iconic. An Introduction to the Typology of Islamic Legal Theory by Aron Zysow, Harvard University, 1984, Cambridge, Massachusetts. The other criterion in this category is related to that of the foregoing doctrine. It holds that when there was a controversy on a point of law among the companions, the transmission of a tradition regulating the controverted question must be at least to the level of mashhur. In such a case, the companion who knew of the pertinent tradition would necessarily cite it to terminate the speculations of their fellows. It is inconceivable that they would conceal it. Put forth in this atmosphere of public controversy, the tradition would be assured an adequate transmission. The Balwa, quote-unquote, public need doctrine was the dominant one among the Hanafis and won the support of the Mu'tazila. Abu Abdullah al-Basri, who dies 369, commensurate with 970, a close associate of al-Karhi, but it was not universally held by them. Those masters who rejected the Balwa doctrine and the related doctrine of publicity following the controversy were not forced to accept the traditions that their colleagues spurned. These traditions were rejected on the ground that they were in conflict with traditions whose validity was better established. We've observed the sharp distinction between the Mu'tazila and the distinction was in relation to knowledge and action. Ilm wal-amal, apologies, no Arabic. Action would be based on presumption, but knowledge depended on certainty. Basing themselves on this distinction, the Mu'tazila accepted a criticism of traditions which was perhaps the origin of the Hanafi doctrines we have been examining. Their criticism recognized a category of unit reports which the hearer could know to be false by their very content. They were traditions reported in private, khafi, a manner which ought to have been reported publicly, zahir. Such traditions are of this very fact known to be false. This is the only case when the subject of the report is public and there are secular or religious motives or both leading to its transmission. Examples are the foundations or usul of the religion, where the motives are purely religious, public events such as court cases where the motives are secular, and miracles where both sorts of motives are at work. What we have here is the Balwa doctrine before the Hanafis extended it to law. The Mu'tazila argument holds that where we are held accountable to know something, the Prophet will have ensured the accurate or adequate promulgation of this information. Otherwise, there would exist an obligation to fulfill the impossible. Quote, "It is not possible that the Prophet impose upon us the obligation to know something without giving us a path to knowledge. But the unit tradition is not a path to knowledge." The Hanafis had a different view of religious action from that of the Mu'tazila. For them, it had an objective basis in the will of God. It was for this reason that they went beyond the Mu'tazilites and demanded that traditions regulating the key elements of religious action be subject to the same rigorous standards as traditions which were the basis of knowledge. The matters to which the Hanafi version of the doctrine applied were precisely those which both scholars and common people needed to know in order to act. يحتاج الخاص والعام إلا بمعرفته لمن عمل به. Apologies, no Arabic given. End of chapter 1. Stay tuned for the summary of chapter 1 and many more parts.